So we had a snowstorm in Nashville last night, and so the whole city is out of eggs and milk and flour and everything else. But that's not the point of this video. The point of this video is, what is the duty that a business or a premises owner has to remove snow and ice after a storm to keep the premises safe from trips, falls, accidents, that sort of thing? So I'll tell you a story. I had a case where I sued on behalf of an injured plaintiff a rooftop bar here in Nashville that refused or failed to remove ice after a snowstorm, and it turned out to be a very tragic situation where a lady suffered a serious injury on her birthday. And so we got into all this sort of issue about, when do you, as a business, have to shovel or put salt down or any of that sort of thing. So it's kind of interesting. You got generally a duty to keep your premises safe for, foreseeable guests, like people who are invited into your business, or if it's your house, you have a duty to keep your premises safe for your social guests. That duty recognizes that in the middle of a snowstorm, you're not going to be able to do that, right? So like, while the storm is happening, you don't have to do anything. So you don't necessarily have to salt beforehand, and you don't have to stop or do anything during the storm. But some reasonable period of time, that's kind of tricky, after the storm has stopped, you've got to clean it up. That's why a lot of businesses go ahead and salt ahead of time, because they're going to have to shovel it and clean it up afterwards. They might as well prevent it from accumulating in the first place. But it's that tricky window of, you don't really have to do anything while the storm is quote unquote ongoing, but you can't wait too long after, because if somebody trips and falls on ice that you didn't clean up after the storm stopped, you could be liable. So in our case, that was 24 hours. And there was cases that say, well, look, if it's a whole day later, you should have had someone out there fixing it. If it was 12 hours later, 6 hours later, 3 hours, you see, it can get a little close in terms of whether that duty has been breached after the storm has ended. So I'm sitting here in the parking lot of a grocery store, and as you can see, this might overexpose the camera, but as you can see, yep, sure did. As you might be able to see, yeah, they've shoveled. Let's get some zoom in there. They've shoveled, they've cleaned, they've done everything that they are supposed to do. So kudos to this grocery store here for complying with their legal obligations to keep this place safe. And I might be able to show you, they've actually shoveled some of the snow up against the edge of the parking lot. That's an illustration of doing it the right way. Now, parking lot cases are actually really tricky, and I don't know if I would take one, but if you've got one, maybe, contact us. But the reason they're tricky is it's kind of what's called an open and obvious risk, assumption of the risk. There's always a comparative fault defense in any sort of premises liability case. If you don't know what that is, I have a video on that I'll share. But they can always blame you. In other words, they can always blame the plaintiff and say, you weren't watching where you were going, you were wearing the wrong shoes, etc. And they will do that in a parking lot case. The rooftop bar case I was mentioning, that was in the business itself. I mean, the plaintiff in that case had made it inside, up to the roof, safely into the restaurant area, and there was ice there. That really should never happen. Parking lot case is tougher. They, obviously they've got to shovel, they've got to, clean away the dangerous condition, the ice and the snow. But if you trip and fall in a parking lot on some ice, they're still going to say, hey, look, didn't you know it was snowing? Didn't you know it had snowed? So to blame the business in that situation might require some sort of facts that are, particularly bad for the business, whether that's there was a warning that there was a patch of black ice, or some sort of latent danger, something you wouldn't necessarily obviously see, like a big pile of snow is something you'd obviously see, but patch of black ice, obscured, some sort of elevation difference or something like that, you might be able to make that work. I should say also, there are sometimes local regulations that will impose obligations on businesses. There are certain ordinances in some cities that require homeowners to shovel their publicly accessible sidewalk. However, every one of those that I have seen cannot be used to impose civil liability on the homeowner. In other words, the city might be able to come along and fine you because you didn't clear your sidewalk. But if somebody trips and falls because you didn't clear your sidewalk, that's not necessarily going to be your fault, right? It's going to require showing something else to show that you were on the hook for that. So I mentioned comparative fault. If you don't know what that is, watch this next video. Thanks so much for watching.